All rise. The Workers' Compensation Court of Appeals is now in session. The Honorable Thomas Christensen presiding.
Please be seated. Welcome to the Minnesota Judicial Center for oral argument before the Minnesota Workers' Compensation Court of Appeals. Today's date is December 29, 2025, and the court has one case scheduled for oral argument. Charlie Anderson versus Country Sun Farm and Greenhouses and Auto Owners Insurance Company, our file number WC 25-6613. Today's argument is being live streamed and recorded. We would ask counsel to speak loudly and clearly when addressing the court this morning. The panel for today's argument are to my left, your right, Judge Deborah Sundquist, and to my right, your left, Judge Catherine Carlson, and myself, Tom Christensen. I know and recognize we have experienced counsel before us today, but as a reminder to each of you, you're allowed 15 minutes to present your argument with a yellow light going on when 2 minutes of time remain. At the beginning of your argument, you will each be allowed 3 minutes of time before I interrupt your argument to ask the panel if a member has questions for you. Counsel is requested to keep track of the time allowed for their oral argument. Any unused time may be reserved for rebuttal. Should the allotted time to a party be extended because of questioning by the court, opposing counsel's time will also be extended. When you step to the podium, please identify yourself and the party you represent. And with that, we can begin. Mr. Schmeichel, I think you are up.
Thank you, Judge. May it please the court, Mr. Lobbs. My name is Jason Schmeichel. I represent Country Sun Farms and its workers' compensation carrier, Auto Owners Insurance, in connection with this matter. In preparing for today's argument, I realized that when my son was much younger, I actually took him to Country Sun Farms on a couple of occasions in the fall. It's the kind of place, to paint a picture, that has corn mazes, pumpkin patches in the spring. It sells flowers, plants, greenhouse equipment. One thing, importantly, that it doesn't do and has never done is sell wood. In fact, it doesn't grow trees and process wood. It doesn't even use wood for fire pits. It doesn't have fire pits for the fall festivities. Wood and the chopping of wood is something that is completely and totally outside of the business model of my client. Now, with that in mind, a couple of things more procedurally. I think that this is undoubtedly a case where these are indisputed facts, and these facts are to be applied to the law as it stands in the context of determining an employment relationship. That being the case, I think that this is an appropriate case for de novo review. With all due respect to the trial level judge, I don't believe that this case justifies granting any deference to the findings and order in this matter. Judge Walther, though, did in her findings and order refer to the relationship between Mr. Anderson and my client as blurry, which is an understated way of putting it. As I think both briefs made clear, there was a friendly, congenial relationship at all times relevant here too between Mr. Anderson and my client and the people who work for my client. Country Sun is owned by a husband and wife. They have 3 adult age children, all 3 of whom work there full time. Chad, who plays a major role in this, is a laborer. He's not part of management, nor does he own any portion of the business. What happened was in 2022, Mr. Anderson was dating Chad's daughter, and they had formed a relationship that was very friendly. On numerous occasions, Chad, along with his siblings, worked with Mr. Anderson and asked him to perform tasks on their farm. Chad has the property that's adjacent to Country Sun Farms, and he raises animals. He does some farming on there. He tinkers around with trucks in his garage. And in fact, Mr. Anderson actually was given a truck by Chad.
Let me
and-
interrupt you at that point. We're
Certainly,
at the
Judge.
3-minute mark and ask whether Judge Sundquist or Judge Carlson or myself have questions for you at this point.
Yes, Mr. Schmeichel, good morning.
Judge, good morning.
Welcome of the snowy morning that we've had
Yeah.
outside. Glad everyone made it safely. You mentioned in your opening remarks that hauling logs, wood was outside the business model of your client, correct? But would it be accurate to say that having a unencumbered, clean parking lot to allow customers to come in and out of the retail facility part of the business model?
Yes, and Judge, that I was getting to that because that is a very important point. And it looks like a lot of the cases that are cited by both Judge Walther and by counsel talk about cases where, for instance, there's the case that I believe was attached to counsel's brief that talks about trees being trimmed around a hospital area. And they say the exact same thing, Judge. In that case, they said, well, certainly it makes sense that if you're going to be the maintenance person on site, that if the employer asks you to also trim a few trees, that furthers the employer's interests, and therefore you can sort of expand the scope of what might normally be considered the normal work activities. What we have in this case, though, Judge, and I looked at this really closely. It's interesting when you come from a perspective of not having tried the underlying case, is that I get to look at these with a fresh set of eyes. And that was the first thing I saw too, Judge. But then I looked at the timeline on this. The lot in which the logs were sitting, these trees were cut down by a tree service, totally independent, in April of 2022. They sat there until July, until the time of the injury. That lot, and the testimony is in the trial transcript, is on page 110, where the Chad indicated that that's a lot that isn't used until they become very busy in the fall. It's not used in the spring, it wasn't used in the summer, and it wasn't going to be used for another 2 or 3 months after that. The only reason why the logs were there is because when the tree service came and cut them down and were going to take them, Chad said, for my own personal use, I want to use these to heat my garage. This would have been a different situation if, let's say, it was the fall. Storm comes through, there are straight line winds, and the actual owners of the company or one of the management people said, hey, we've got a busy weekend coming up. Halloween is on the horizon. And kid, you better get down to the lot where a bunch of people are right now because we're going to lose money if those trees aren't gone. That is absolutely not the situation that we have in this case. The trees, the fact they were there and the fact that they were going to be cut and hauled over to Troy's facility, which is not Troy, Chad's home, which is totally separate and completely unrelated to Country Sun Farms, was completely and 100% for the benefit of Chad. If this had been a situation where the trees had come down and independent tree service was brought in as it was, and the very next day or that weekend was going to be busy, presumably, and I think it's fair to extrapolate from the evidence, that there wouldn't have been the option of, hey, Chad, do you want to come in and take these trees home? The tree service would have just taken them.
Redone, okay. Mr. Schmeichel, you've said some things here, and there are many things listed in the brief. For example, that your client didn't own the log splitter, that no part-time employees worked in July, that Chad Bergman was not an owner. And I understand that these are facts and part of the evidence. But my question for you is, how many of those things were known by or communicated to Mr. Anderson?
As I went through, and I made a list of those, Judge, as I was going through this as well. My list includes that Mr. Anderson was a family friend. He worked for others, Chad and the other siblings
but-
on numerous occasions.
Right, but of the business thing that I explained to you, and there were a few others. So, but these are business things that your clients knew, but how many of those would have been known by Mr. Anderson, the 17-year-old that, you know, again, had a blurry relationship with Chad Bergman and with the employer?
I submit to Your Honor that I'm not stating this is in just I think it's reasonable to assume that all of them. The day that this injury occurred, first off, he'd been working, and the record shows this. He'd been working with Chad, the father of his girlfriend, on numerous occasions. He'd been over to his house in his garage. They'd been working on cars. They'd been doing all sorts of other things. On the date of the injury, he was stacking hay and removing asphalt slabs that he even acknowledged on the record, he being Mr. Anderson, that he didn't believe those were in any way related. In fact, there were a number of other situations.
But Mr. Anderson also testified that when he did work on the property of Country Sun Farms, he was paid by Country Sun Farms. Is there any evidence that Mr. Anderson knew about the, what I would say, the corporate structure or an organizational chart of who owned what or who managed what at Country Sun Farms?
It's almost a lack of evidence showing that he did. I mean, he did testify that his job duties when he knew that he was working for Country Sun Farms were vastly different and never involved cutting wood. He clearly knew that they were using a truck that was owned by Chad, a log splitter that was owned by Chad, and they were hauling that wood to Chad's home. He'd been in Chad's garage, and he knows that he heats the garage.
Well, let me ask you this.
Sure.
Do you think it's controlling or even relevant what Mr. Anderson understood about who was in charge or who was the employer that day? Should that factor into this at all?
I think, and I was looking at that as well, Your Honor, because there are some of the older cases talk about how that it was reasonable for this worker to assume that they were. So I thought about that in the context of this case, and I don't know from a legal standpoint, with the exception of one thing, where he's taking direction. I think that if you look at some of the cases that have been cited by counsel and Judge Walther, people are directed to do work that may have been outside of the purview of what they actually were hired to do, but they were directed by people who they knew to be their supervisor, and they had that only one relationship with them, which was my only relationship with the person who's directing me to do stuff is that employment relationship.
But wouldn't Chad Bergman be the supervisor regardless if it was at Country Sun Farm or at his own property?
He was a laborer. I mean, he wasn't a supervisor in this case. He wasn't, and I understand from what I think the history between Mr.
In Mr.
Anderson.
Anderson's shoes. Well, let me ask you this. Isn't it true that it was Chad Bergman that hired Mr. Anderson by text?
I think it was, yeah, I think that there was a text reaching out like, hey, do you need help around the Country Sun Farms? So yes, that is true.
Okay. And so it would have been Chad Bergman that would have supervised it to some extent, whether it was on the Country Sun Farm property or on his own property.
Supervised in a loose sense. They had the type of relationship that wasn't even, for instance, let's say that the question is whether Mr. Anderson at the time of the injury was an employee of Chad, not Country Sun Farms. That would be kind of a different thing, but they had the type of relationship, including the dating of the daughter, and also the fact that he'd helped out, and he testified that he liked to help out Chad. And he sometimes got paid, sometimes didn't get paid. He regularly recognized when
And
he
I agree
was
with all
helping
that,
out.
but he was also an employee of Country Sun Farm. It's not that like he never worked there.
Correct.
He was on their property and he was paid on other occasions, right?
Yeah. Oh, yes.
Okay.
Yes. And he hadn't worked there for a long time. It was a handful of months, and there was some question as to how much he'd earned, but they thought it was less than $600. And he, at the time of the injury, he hadn't worked, hadn't been scheduled. hadn't been paid by, hadn't for at least 3 weeks. No part-time employees were working on that date. In fact, nobody was working on that date for Country Sun Farms.
Mr. Schmeichel, Judge Carlson, are you
Yes,
finished? Okay,
thank you.
couple things. Number one, standard of review. You understand as a reviewing court, if this is a factual issue, the standard of review is substantial evidence, and it's very difficult to overturn a compensation judge. Um, y- you had the burden of proof in showing a causal employment here, or casual employment, excuse me, casual employment here, but you did not meet that burden. How would you argue that the compensation judge was looking at the evidence, rendered a decision that was manifestly contrary to the evidence in this case?
Well, the primary argument, Judge, is the employment relationship, that it didn't arise out of it in the course and scope of.
Which is a factual question.
Correct. Correct, which I think is subject to de novo review. But
Under what authority?
under the hold on. I believe that the Krovchuk, Krovchuk versus Coke Oil case, which is 48 WCD 607. It's a 1993 case. Indicates that when a decision that rests upon the application of a statute or a rule to essentially undisputed facts generally involves a question of law, which the Work Comp Court of Appeals may consider de novo.
And why should we consider it de novo in this case, if it's a may and not a mandate?
I think in this case, because I think that there was essentially a mistake of law in finding that this fell into to an employment situation. I think that the only nexus, the only connection is so tenuous, such as to not even really exist, and that just is that the logs were on the property of my client. But again, as I explained earlier, that if they had to be removed by the next day or the week, or even within a couple of weeks, then there would have been some rush. They would have lost business, but that's not what this was. These things had been sitting there forever, and they would have continued to sit there, and they wouldn't have even been there. But for the fact that from a totally personal perspective, unrelated to the business of Country Sun Farm, Chad, on his own, wanted those for his personal use.
So let's talk about those logs being there. So you said they were there in April, right? They were cut down in April.
Correct.
And I know you've gone past the time, if that's okay with
That's
council, judges and council. They were there since April. So April, May, June, pretty much the end of July.
Correct.
And they've been sitting in the parking lot all those months. We've got they have a fall retail event beginning in early mid-September. So literally like 6 weeks away. When I looked at this case, I thought there had to be some sense of urgency in getting those logs off that parking lot. It wasn't established, but I mean, it just made sense to me that that's what would happen. Am I wrong?
I think if there was urgency, they would have been taken off within days or weeks of when they were put there. I think the fact that it took 3 months for him even to get around to it shows that there was no urgency. And to the extent that there was urgency, it was not created by the business. It was created by Chad, just saying, okay, I'm going to get these logs. I'm going to take care of them at some point. I'm using them for my own personal use. I don't think there was an urgency. Again, I think the straight line win scenario, where it was like, wow, we're opening up our fall season in a week or this weekend. We need to get those logs off of there. But that's not what happened.
I have one more question. My question is related to the employment records. We know in this case, there were no employment records for Mr. Anderson. My question is, Was Mr. Anderson given any kind of notice that his employment, seasonal employment had ended?
I'm not aware of him ever been giving notice that his seasonal employment had ended.
All right, thank you.
I have nothing else.
Thank you.
Thank you.
And as you get ready, Mr. Lobs, just so you're aware, we'll give you another extra 1 minute and 20 seconds of time here. So you'll have 16 minutes and 20 seconds as you
Thank
move
you, Your Honor.
forward.
My name is Joshua Lobbs, and I represent the respondent here, Charlie Anderson, who's in the courtroom with us. May it please the court, counsel. Thank you. I'm humbled and thankful to be here. It's an interesting case in the sense of my creativity couldn't come up with the webbing of relationship, employment relationship, a 17-year-old, a good employer on all accounts, a good family, good relationship, even maintained by the injured worker and the employer in this case. Really, there's no villains, save for except perhaps the chicken. You know, if a dove is a harbinger of peace, then the chicken must be a harbinger of chaos. But in this case, the way I see it, I want to address first the standard of review. I believe the law is extremely clear that whether or not an employment relationship exists between an employee and an employer is a fact question. Elwell versus Flake, Gibbard, there's long lines of case law that establishes this. And I believe the standard of review in this case is not a de novo review. I believe it's whether or not substantial evidence exists such that the compensation judge's findings is supported by substantial evidence. And the way that I read Hengemule and its progeny is that if a reasonable person or reasonable inferences can be drawn from sets of facts, then that fact finder, that compensation judge, those decisions should be upheld. And in this case, I must confess that I think some of these issues, such as the employment relationship, such as whether or not the employment itself was casual, are kind of close calls. And the advantage of the law for the respondent is that close calls go to the runner, close calls go to the judge, and they should be affirmed so long as any reasonable inferences can be drawn from sets of facts. What I want to talk about first, I believe, is to frame what I believe the potential ways for the appellants here to prevail. I think they have to show that there's not substantial evidence that supports a finding of an employment relationship at the time of the injury, meaning that the injury itself, on July 22nd of 2022, Charlie Anderson's hand being crushed in the log splitter, that on that date, that the injury did not arise in the course and scope of his employment. That's a way for them to get an out. Another out is that they have to prove both of the provisions of 176041 subdivision 1 subsection 11, which is that the employment itself was casual and that the employees engaged in activities that are not in the trade, business, profession, or occupation of the employer. And I think they have to prove both of them, that there's not substantial evidence being able to sustain the judge's findings on both of those issues in order to have an out on the casual employment issue, which is sort of a two-tiered question under the statute. With the sets of facts that we have here today, and first I want to address just a couple of the things that were brought up on the questioning of counsel. One is the nature of the relationship between Chad Bergman and the...
Let me stop you just right there. It might be a good time. We're at that 3-minute mark, so I'll ask Judge Carlson and Judge Hunquist whether or not they have any questions for you at this point in time.
I do. And Mr. Lobbs, I think maybe you were just getting to this, but does this case in some manner hinge on what hat Chad Bergman was wearing that day as supervisor of his personal farm versus some supervisory role for Country Sun Farms, or does it even matter?
I think it matters in two respects. One is whether he was an owner is not the question, really. I mean, but there's evidence that Charlie thought he was the owner at the time. But really, he's a person that hired Charlie and that would pay Charlie. And Mr. Anderson, the employee, I don't mean to be cavalier or too casual. Chad Bergman, there's evidence supporting the idea that he hired the employee, that he paid the employee, and that he had control, the ability to call him into work, the ability to drive him different places. Both Chad Bergman and his spouse, Colleen, there's record about them directing the specific work activities. There's like 19 different work activities that he had done there. But it matters insofar as the control and whether or not he's a supervisor type. I think there is substantial evidence in the record to support a finding of that on that day.
Well, and let me ask you a similar question to what I asked Mr. Schmeichel. There are plenty of what I will call business facts about ownership and organizational charts and when certain employees worked at certain times, which may or may not have been communicated to Mr. Anderson. Is what Mr. Anderson understood or was told, is that in any way controlling or even relevant to the outcome of this case?
Judge Carlson, I think it's relevant in the sense that O'Rourke versus Percy Vedum tells us that what the employee understood when there is sort of a dual nature to the relationship between the person directing him what to do and his employer, meaning his employer, Percy Vedum, as a person, in that case, had this employee come out to Percy Vedum's own house to remove some cedar trees. And the court sort of wrestled with that. The Minnesota Supreme Court in its 1925 decision really struggled with what the employee knew or didn't know. And in that case, unfortunately, the employee had passed away, so they didn't have much evidence as to what he knew. But ultimately, there was inferences about what he could have or would have known. And in this case, I think it's somewhat similar in the sense that, at the time of the injury, we have a 17-year-old individual who, is working for the person that hired him, who's part of this family farm that's run, and ultimately is doing things at his direction. And admittedly, on that date, earlier in the day, he had done essentially two different tasks for the direction and for the benefit, the personal benefit of Chad Bergman himself. But then Chad Bergman drives Charlie Anderson and Ian McDonough, another employee of Country Sun, to Country Sun's property to remove Country Sun's logs at the direction of the person that hired him and had control over him and directed him what to do and had the equipment. None of the equipment's Charlie's. So I think in this circumstance, the nature of the relationship between the employee and the person directing his has an importance for two reasons. One, control of the activities of the individual is one of the primary factors as to whether or not an employment relationship exists. So I think it's relevant in that sense, but it's also relevant in the sense that I think, and not explicitly, but certainly implicitly in O'Rourke versus Percy Vidum, we understand that the court wrestled with that analysis and said, what the employee would have thought or would have understood or did understand is relevant to the nature of the relationship between two parties.
Thank you.
And I have a question for you. You mentioned a couple of times, I think Mr. Schmeichel did as well, family farm, which is also an exclusion under the Work Comp Act. That wasn't argued at the hearing.
Not at all, Your Honor. And in fact, I think it's undisputed, but it would not apply in this circumstance for a variety of reasons.
And my next question is, there's been some discussion and listening to the argument today and going over the cases. And it wasn't again argued at the hearing, but it would seem to be, there's some, at least from the defense, Country Sun, that the real employer, if there is an employer in this case, is Chad Bergman and not Country Sun. But again, that argument wasn't made as far as I can see.
No, that's correct. There was never a defense that was asserted nor an issue raised to the judge from the employer or from anyone that there is an alternative employer such as an individual. And it's not a claim that the employee brought.
And then following, it would seem to me that the kind of fact situation is, as you mentioned, Chad Bergman directed Mr. Anderson and Ian McDonough on the day that the injury occurred. And no one had ever seems to have told Mr. Anderson at all that when you do work at the personal property of the Bergmans versus the property of Country Sun, you're not covered for work comp, or you're not an employee of Country Sun when you're doing personal work, only when you're on Country Sun. But I think it's undisputed in this case that the injury happened at Country Sun, if I'm correct. And looking at the totality of the circumstances without anybody telling Mr. Anderson anything, how was he supposed to know he wasn't working for Country Sun when this injury happened? Is that a fair kind of scenario in my mind, or am I wrong?
I think that's right, but not only that, I think if we look at the employee's testimony in the transcript, and this is on page 31, lines 24 through 32, through 32, line 6. There's a question, and this is what's posed to Charlie Anderson himself. How about, and what the question is who's he's doing the work for? And this is in the line of questioning. The question, how about when you were splitting logs in the parking lot? What was that? The answer, I figured that was for the farm because we questioned, why did you figure that? Answer, well, I wasn't told who it was for, and I never was, but I figured we were at the farm doing something specifically of the farm. That would make sense. It's for the farm. And here the farm is Country Sun Greenhouses and Farm. It's the employer. So we certainly have testimony delivered at the hearing from which the judge can make findings. And I think this essentially goes to the heart of, if we're honest in sort of a categorical characterization, there's probably and likely, and evidence supporting this, a dual nature to the activities out there. The employer wants to focus on the personal nature of the firewood, the wood to be used at the personal garage fireplace of Chad Bergman himself, not as Country Sun, but as an individual. But certainly he's also, it's really undisputed that they're removing logs owned by Country Sun on the third parking lot of Country Sun at the direction of the person that hired him at Country Sun with 2 other employees and nobody else for Country Sun. And so I think, you know, there's a really robust case law about what employees can do to take themselves out of work environment. There's not a lot of case law about what takes them back into the work environment, but this appears to be one of those circumstances. And which is,
That's a very good point, Mr. Labs, and I want to ask you about that. So O'Rourke, which is the case you've cited previously in your remarks, 100-year-old case. And the case is one in which the lines between employment relationship and arising out of it and the scope and course of are blurred, because back then they didn't have all of the cases that we now look at to distinguish employment relationship, exceptions to that relationship, and then did it arise out of and in the scope of employment, right? So it sort of lumps everything together. So my question is, in this case, like in O'Rourke, did the employer enlarge or extend the scope of employment? Because that seemed to be one of the primary considerations that the court looked at, is did the employer expand or enlarge the scope of employment? Here we have this young man who works for the employer in the retail, doesn't get any notice that his job has ended, which is under other statutes in Minnesota. That's a requirement, right? You have to have some sort of ending to the employment. But then is contacted again by Chad Bergman to do additional work. So in that setting, was his employment relationship extended from the alleged June date, because we don't have really evidence that would suggest it was actually a termination of employment at the point, to his hiring to do the work in the parking lot?
yes, Your Honor, I believe that it was expanded, and I think it's sort of relevant as far as I read it, not only O'Rourke, but some of the subsequent case law for 2 reasons. So first I want to correct you, and it's actually not necessarily for our benefit. There's a perspective that the employee, what he actually did is he texted Chad Bergman and said, hey, just finished hauling brush somewhere. Anything else for me to do on board? LOL. You know, a really sort of innocuous. And then there's a conversation and text back and forth. Yeah, actually tomorrow we're doing the hay, right? And then Chad Bergman instructed him, we are also going to be removing the firewood from the parking lot, right? And so Chad Bergman is the one who specifically solicited that additional task, which is the ultimate task that took place on the employer's property, and is the one that, obviously resulted in the injury. So, but it's also sort of relevant, I think, in the context of casual employment. And this is one thing that I want to address, is that when we look at some of these cases, for example, like Chisholm, and this is also a case I cited in the brief, Cocktenny versus City of New Prague. When we look at some of those cases, there's sort of a dual nature to it. There's both an ongoing sort of employment relationship, but then there's also specific arrangements for additional work for money. So like in Chisholm is a case where an individual was employed in the sense that he was collecting, rent was $15 to $18 a month. Those were the days. So a person that was also a resident in a panel of these houses, he was getting relief. And so he's getting $5 off of his rent for collecting and doing repairs as needed as they arose. So sort of periodic work and then at the end of the month work. And then additionally, the employer said, we'll pay you 15 cents to remove these screens and windows and wipe them. And what happened is in Chisholm, the employee got injured doing some of the screen work, which is sort of a separate type of task. And he was not getting what the employment relationship was for. It was what the court called a special arrangement. But the court really does an interesting analysis in Chisholm, and it says there's not two employments here. It's whether or not there's an employment relationship. And in Chisholm, it's interesting because it's within the context of a casual employment case law, because that's really dealing with casual employment, which is really the defense that was brought on here. So the court not only looks to the work that's sort of the regular work that the employee would do, which in that case was sort of periodic and limited and sometimes as needed, but then also the specific tasks for which there was direction and payment, but it just happened to happen on particular days. And what the court really struggled with is what the court outlined is that if there is an employment relationship that's ongoing, then it's not casual, even if the particular task happens to be periodic. And in this case, as far as I've reviewed, there's not case law providing opinions that seasonal employment is under the ambit of casual employment analysis. But I will direct the court's attention to Neubauer. And this is the decision.
Okay, Mr. Lobbs, you're out of time, so if you want to finish this thought, and then I'll ask the panel whether they have any final questions for you, but if you can.
Thank you,
kind
Your
of
Honor, and I
wrap things
apologize.
up.
The Neubauer versus Pepsi bottling group decision. And in that case, really briefly, there's an analysis of what the employee had a primary job. This is a 1990 WCCA decision. The employee had a primary job of working for a printing press, but he had seasonal work where he was also doing lawn care between April and November. So it was seasonal work. He gets injured in March, so outside of sort of the regular season. And the question in that case was really an analysis of whether the second job constituted regular employment such that it should be included in the average weekly wage. So it's not an issue of casual employment. But the interesting thing is, in that case, the court stated the term regularly employed is used in contrast to casual employment, a distinction which must be determined with the principal reference to the scope and purpose of the hiring. When there is continuing engagement to serve the employer in his business at such times as the particular and essential services might be needed, the employment is not casual according to any of the definitions of that term. And we know in this case, there's evidence presented that he worked in the spring. He worked before the spring season. He worked through the spring season. It's a little unclear. There's disputed when he worked. And then he is doing this particular task in July. And then he worked in the fall. There's a continuing ongoing relationship there between the employee and Country Sun in this case. Thank you.
Thank you. Any other questions?
Nope.
Nope. Thank you.
Wait, I have a
Oh.
question.
Oh, okay. Sorry.
Casual employment. I have a question about that. It seems really difficult to prove that. And I'm just wondering, if you can come up with any thoughts about what circumstances would grant a finding of casual employment. I don't see a whole lot of solid examples in the case law. Can you
Well,
comment on that?
So under the Bill Meyer case, under Amundsen versus Pope, under the last two cases that this court has decided in 2007, Rectifrag, if I'm saying that right, and under Withus, the primary scenario that this appears to come up in our case law is really in sort of people working at some person's house, doing some project work, whether that constitute an employer and employee relationship. So certainly casual employment, where it's periodic, task-oriented, you're paying somebody cash or maybe check or some other method, but you're paying them for not sustained relationship where they're expected to have ongoing income or ongoing control relationship. Certainly it applies in cases where people do project work at the house. But, you know, there's other scenarios where it might be periodic, and I think Bill Meyer and I think Amundsen versus Pope really sort of wrestled with, you know, there's language in those cases that says casual employment is not easily defined and it could mean several different things. In this case, I think even if this court were to say that substantial evidence is not supported, there's casual employment, certainly by the admissions of both Chad Bergman and the case law that we provided, removing the wood from this parking lot to be cleared is in furtherance of the employer's trade, profession, and occupation. And I think so, even if it weren't to be found to be casual, the employee still prevails.
Thank you, Mr. Lobbs.
Thank you.
Thank you, counsel. It was very helpful to the court today. We are now adjourned and the matter will be taken under advisement and a decision issued in 90 days. Thank you very much.
Thank you.